All right, good morning, everybody. Court will continue here with the January 27th, 2022 docket, and it's the 11 o'clock docket. We have Mr. McLaughlin, who is connecting. What did you want to do? This one here, JP Pena. All right, Miss Pettis, good morning.
Morning, Judge. How are you?
Yes, ma'am. Fine, thank you. You're here on F2104-214 in the matter of the marriage of Mosqueda and Mosqueda.
Yes, Your Honor.
It's a motion to withdraw.
I believe opposing counsel has filed a motion to withdraw, and I'm not opposed to that.
And the opposing counsel is J. Pena.
Yes, Your Honor.
All right, then we'll grant it. I don't see him in the waiting room, but we'll go ahead and grant it
Okay.
to be signed. Is that all we have in this case, ma'am?
For now, yes, Your Honor.
Well, thank you so much. You'll have a great day and stay safe, ma'am.
Okay, you too. Bye.
Bye-bye.
Bye-bye.
What else do you want to call this? All right, Mr. McLaughlin.
How you doing, sir?
Hey, good morning, sir. Which is your case? Do you have a couple of cases?
I have two portfolio recovery cases.
Okay. I have here number one. Number one is CL 182322D, Portfolio Recovery Associates LLC versus Juan Rodriguez. And I don't see Juan Rodriguez
So
in the waiting room. So the court will take judicial notice of the entire file, and you may proceed, sir.
in this case, we believe that he had opened up a Walmart credit card on August 5th of 2011. He made his last payment on May 14th of 2016. The account was closed and charged off with a balance of $1,068.62. We're seeking that amount in damages plus costs to the court. We're to ask the court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature.
Okay, I will make sure it's e-filed today.
All right, thank you, sir. Then the next one is CL 182893D, Portfolio Recovery Associates LLC versus Cebet Armenta. And no, she's not in the, said person is not in the waiting room. So I guess court will take judicial notice of the entire file, and you may proceed, sir.
In this case, we believe that, again, she had opened up a Walmart credit card on June 10th of 2010. And she made her last payment on September 17th of 2016. Account was closed and charged off with a balance of $2,997.61. We're seeking that amount in damages plus cost to the court. We're asked the court to take notice and admit the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
All right, the exhibits so admitted. Court will hereby take grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in this petition. Court will await a default judgment for signature.
Thank you,
Is
sir.
that it, Mr. McLaughlin?
Yes, sir. That's it for today.
All right, thank you so much. Your excuse. Have a great day, sir.
You too, sir.
Bye-bye. All right, next case, I have Mr. Pope and Mr. Garcia.
Good morning, Judge.
Morning, Judge.
Good morning, gentlemen. I think we're here on CL 196097D, Glenda Molina versus Monroe Law.
Yes, Your
Yes,
Honor. You're going to see
Judge.
on behalf of the plaintiff.
All right, gentlemen, and what do we have here?
Judge, I filed a motion, a discovery motion, and I visited earlier this morning with Mr. Garcia, and we basically have worked out the matters in dispute between us, and we're going to submit a Rule 11, basically to wrap up the discovery and get the expert deposition done, and hopefully get the case settled. But if not, in any event, we've worked out the matters, and we're going to do a Rule 11 between the parties with reference to
Okay.
that.
Very well.
That is correct.
All right.
Your Honor, you have a great deal more white hair than I remember from the last time. But at least you have hair. I have
At
the
least
opposite problem. Yeah.
Okay, at least I have her. Okay, thank you so much.
Thanks,
for,
Judge.
Thank you, Judge.
okay, y'all have a great day. Stay safe. Okay.
You too.
Bye-bye.
Thank you. Bye-bye.
All right, Mr. Bustos and Mr. Pequeño.
Yeah, good morning, Judge.
Good morning, gentlemen.
Good morning, Your Honor.
I think we're here on CL 21-16-56D, Pedro Cantu et al. Versus Magic Valley Services Inc., Las Toronjas Ltd. It's an motion for it's an MSJ, right? Motion for summary judgment.
Yes, Your Honor, that's correct.
All right, and whose motion is it? Is it yours, Mr. Pequeño?
Yes, Your Honor, Juan Pequeño for the defendants, Magic Valley Services, Inc. and Las Toronjas Limited.
Okay. All right. And did you file an answer, Mr. Bustos?
Yes, Your Honor, it's been on file the requisite period of
It's
time.
been on file. Okay, very well. Okay, then court will take judicial notice of the entire file in CL 21-16-56D in the case of Pedro Cantu et al. Versus Magic Valley Services Inc. et al. And you may proceed, Mr. Pequeño.
Thank you, Your Honor. So this lawsuit arises from sale of some real property, Your Honor. It was lot 76 in Las Toronjas subdivision. This sale occurred back in, I believe it was March of 2020. Basically, property was sold subject to, all easements of record. There's a recorded plat and all of that. The transaction is financed by my client, Las Toronjas. The plaintiffs, Mr. Cantu and Ms. Carmen Cantu, purchased the property and financed it. They have stopped paying on that note and essentially brought this lawsuit claiming that they were not made aware of an easement on the property, that affects what they claim their ability to construct on the property. We filed our summary judgment on both a traditional and a no evidence summary judgment, Your Honor, on a number of grounds. The two causes of action that have been alleged are breach of contract and breach of the duty of good faith and fair dealing. With respect to the breach of duty of good faith and fair dealing, Texas law does not recognize that as a cause of action with respect to contracts, absent some special relationship, which there is none in this. This is your typical buyer-seller transaction, Your Honor. So based just legally on the law, that not being a valid claim, in these circumstances, we think summary judgment should be granted as to that cause of action. Now, as far as the breach of contract cause of action, the basis for that is that the plaintiffs are essentially asserting that they didn't have any notice of an easement on the property. Well, the summary judgment evidence shows otherwise. And first and foremost, as this court probably knows, you're charged with knowledge of anything that's in the real property records. And what is in the real property records is a copy of the plat, and that's attached to our summary judgment evidence. And it clearly shows that there is an easement that goes across this property. So the purchaser acquired this property bound by that knowledge. Not only that, but the actual deed that he acquired title or that they acquired title from expressly states in the deed that they're taking subject to all visible and apparent easements on or across the property, all recorded restrictions and covenants, and along with the plat, and the plat specifically references this easement. The deed also expressly states that they're taking as is, where is, and with all faults. So essentially, it's first of all, they're charged with that notice of this easement. And it's incumbent on them to do their research, do their due diligence on the property as to what they want to do with it, and all of that. Now, another thing we have in our summary judgment as evidence is aside from the deed and the plat, which clearly show that this easement was there and they were aware of it, had they just looked at all of the paperwork, is in a closing checklist that they signed. They acknowledged essentially that they had already inspected the property, that there were no representations being made as to what they could build on it, and that that they understood that it was subject to a subdivision plat and subject to any easements of record. So in writing, they acknowledged that they knew about all of this, and they're charged with notice legally under the law. So that's the basis for our summary judgment. So pretty straightforward, Your Honor, in terms of what our position is. We also filed a no evidence along similar lines. Our position is there's no evidence that they performed all conditions precedent. The other thing is they cannot show that they've performed or tendered performance under the contract because they're in default under the contract. They haven't paid on this particular note in months, and it could be even more than a year. There's no evidence of any breach on our part. We sold them the property. It was subject to any and all easements. They were responsible for doing their due diligence with respect to all of that. Now, in response, they did file about a one-page affidavit from Mr. Cantu, and we've objected on several grounds. First of all, the affidavit sets forth that supposedly a representative of the defendant said that, and let me pull it up here. The affidavit states, I inquired about the property and was informed by a representative of the defendant that there were no restrictions to prevent me from building a shed or any other dwelling, specifically a storage shed. So we don't have any detail of who it was that made these representations, when, what was said, nothing. It's a pretty blanket statement, but essentially, excuse me, Your Honor, that's in violation of the parole evidence rule, which we have a written contract that sets forth, all of the terms. And so they're trying to contradict that with some prior statement, when essentially everything has been merged into the contract. The contract is what governs. They can't go back and try and bring up prior issues. So aside from that, Judge, there are some legal conclusions in that affidavit. Basically, they're just saying they breached the contract and they are invited. It says here they breached their duty of good faith and fair dealing. I mean, it's purely conclusions, legal conclusions for that matter. There's no evidence as to what was done, how the breach was done, or anything like that. And then the other issue they seem to raise is that they allege that the contract was not translated to them, which there's no legal requirement. And we have briefed that issue in our reply to their response. That they're presumed under the law to have read what they signed and understood it. And one of the things that they initial and sign off on the contract is that they have read the contract, or if they don't understand it, they've had it translated to them. So they even acknowledge that in signing it. So we're not legally required to do that. So aside from the objections that we've raised to this sole item presented as summary judgment evidence, we think legally that there's nothing that's being raised to raise any fact issue on our traditional or no evidence summary judgment.
All right, thank you, Mr. Pequeño. Mr. Bustos?
Good morning, Judge. We do have a file response as we deferred to our file, our answer on file, Judge. Clearly, we're going to have the opposite argument of Mr. Pequeño, and I believe that there's numerous allegations that we've made and conveyed in our answer, Judge, and our petition, Judge. So I ask the court to defer to our answer, Judge.
Okay. Court will go ahead and take the matter under advisement, and of course we'll review both the motions and any responses thereto. So anything else, gentlemen?
That's it, Judge.
That's all we have, Judge. We just asked, I did file some proposed orders this morning.
Right, I was gonna, okay,
Yeah.
I was gonna ask on that. Yeah,
I-
submit proposed orders.
Yeah, I submitted one on the summary judgment as a whole, but also on the individual objections that we asserted. And again, we lay out our argument as to what the basis for our objections are.
Okay, all right, very well.
All right, Mr.
Then,
Pequeño, you have a good one.
Thank you so much. You all make both my big excuse. Have a great day.
Thank
Bye-bye.
you.
You guys.
Bye-bye. Number 10, number 10. Who's gonna be number 10? All right, number 10 here, F62 26 19 4 in regards Andres Ramirez.
Good morning, Your Honor.
Yes, sir. Good morning. You Mr. Ramirez, right, sir?
I am, sir.
All right, you're seeking a name change?
I am, Your Honor.
All right, and the name change is to what? To
To Andres Moretti.
Moretti, Moreti?
Yes, just I guess Moretti. I believe
Oh,
that's correct.
I left out one T. All right, there we go. And so, and the purpose of the name change, Mr. Ramirez?
Yes, Your Honor. I've been going by that nickname for a few years now, and I just stuck with me. So I would like to have it officially as my name.
Okay, and so you understand that once you change your name, you're gonna have to go through a lot of paperwork with so many agencies to get back to a name change. You understand that?
Yes, I understand, Your Honor.
Secretary of State, DPS, I don't know who else and whatnot. Anyway, but you're not doing it to defraud creditors or anything like that, or commit a crime, or
No, Your Honor.
none of that. That's not the purpose, right?
No, Your Honor.
All right. Did you submit an order for the court signature?
I submitted some documents. I would like some clarification on what signature might that be.
The actual order granting you the name change. That's
I
what I'm
did.
talking about.
I did, Your Honor. I have it.
Okay.
I believe I have it here.
Okay, then your motion here, application is granted. It'll be signed later on. Okay, sir?
Thank you, Your Honor.
All right, your excuse. Have a great day. Bye-bye.
Thank you.
What did you have? Number 9. Number 9. Mhm. All right, we got Mr. Ortegon.
Good morning, Your Honor. How you doing, sir?
Fine, thank you, sir. Good morning. I think you're here on F5177-21-4 in the interest of Isabela Gonzalez.
That is correct, Your Honor. Jorge Ortegon. I am here next to my client, Israel Gonzalez, who's sitting here to my right, Judge. We are present and ready, Your Honor.
All right. Now, how about the mother? What's the name of the other party?
The other party's name, Your Honor, is Miss Karina Farias. We did speak to her earlier, Judge. She should be logged on. Karina Farias.
Karina Farias. Okay, she's okay. I'm gonna try to bring her in. We're gonna see if that's her.
Yes, and
You recognize her?
that's her, right? That's her, Your Honor.
All right, she's logging in right now. She's connecting. And by the way, she doesn't have an attorney.
She does not have an attorney, Your Honor. And actually, with this honorable court's approval, we are set for temporary orders, but we have come to an agreement. It's not a divorce, just a SAPSR. So
Yes,
with this
SAPSR.
court's approval, we would like to hopefully see if we can just prove it up and finalize this case today, Judge.
Okay. Now, Miss, I think I see Karina already, but she needs to unmute.
Okay, there you go. Sorry about that.
All right. Oh, that's fine. Good morning, ma'am. All right. So once again, Mr. Ortegon, well, first of all, we're all here on F5177-21-4 in the interest of Isabela Gonzalez, and Mr. Ortegon is on the screen there with his client, Israel is Garcia?
Gonzalez, Your Honor.
I'm sorry, Gonzalez. All right, Gonzalez. And there's Miss Karina Farias on the screen. And I understand, Mr. Ortegon, we have an agreement?
Yes, Your Honor, to finalize this case with this court's approval.
Oh, okay. And you want to call your client as a witness?
Absolutely, Judge.
All right. Mr. Gonzalez, good morning, sir.
Good morning, sir.
Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down, and Mr. Ortegon, you may proceed, sir.
Thank you, Your Honor. Sir,
Yes,
will
sir.
you please state your full name for the record?
Israel Gonzalez?
Okay, Mr. Gonzalez, and you are the father of the child subject to this suit, is that correct?
Yes, sir.
What is your daughter's name?
Isabella Gonzalez?
Okay, now your daughter, Isabella, how old is she?
3.
Okay, and you are a resident of Hidalgo County, Texas, is that correct?
Yes, sir.
And your daughter's a resident of Hidalgo County, Texas, is that correct?
Yes, sir.
Okay, and we've had ample time to discuss this case and how we want to approach this case, is that correct?
Yes, sir.
Okay, and in fact, we have come to an agreement with Ms. Farias as to how we want to resolve this matter, is that correct?
Yes, sir.
Okay, now the decision we have made is that you and Ms. Farias would share custody of your daughter in a 50-50 basis from Sunday at 6 p.m. to Sunday at 6 p.m. Is that correct?
Yes, sir.
Okay, and even though it's 50-50, you have offered and volunteered to pay her child support in the amount of $600 per month. Is that correct?
Yes, sir.
Okay, you guys are both going to be joint managing conservators with no primary conservator. Is that correct?
Yes, sir.
And if you could speak louder.
Yes, sir.
Okay, now, however, mother is going to have the right to designate the child's school. Is that correct?
Yes, sir.
Okay, so though there's no primary designation, you understand that mother is going to designate the school that the child is enrolled at. Is that correct?
Yes, sir. I understand.
And you also stated that you would be the obligor for health insurance. Is that correct?
Yes, sir.
And she does have insurance through your current employment.
Yes, sir.
Okay. Now, do you believe, and obviously some days you leave for work, but you understand that you can designate a competent adult to do pickup, drop-offs, and to be with your daughter while for the days that you are maybe not here. Is that correct?
Yes, sir.
Okay, and do you believe that this agreement is in the best interest of your daughter?
Yeah, I do believe that.
Okay, and did you make this agreement freely and voluntarily?
Yes, sir.
Were you forced in any way to come up with this agreement?
No, sir.
Have I explained to you all your rights as a father?
Yes, sir.
And are you happy with the services and advice I've given you as your attorney in this case?
Yeah, I am.
Okay, and were you and Ms. Farias ever married?
No.
So this is just a SAPSR, is that correct?
Yes, sir.
Okay, and were you asking that this honorable court approve this agreement that you have with Ms. Farias?
Yes, sir.
Judge, at this time, I would pass the witness.
Okay, and Ms. Farias, did you hear the testimony?
Yes, sir.
And you're in agreement, ma'am?
Yes, sir.
All right, court will take judicial notice of the entire file in F5177-21-4 in the interest of Isabella Gonzalez, minor child. Court will hereby go ahead and approve the agreement of the parties and will await a decree for signature on the SEPSAR.
Absolutely, Your Honor. If I can have about maybe a week and a half to prepare it, Your Honor.
That'll work.
Thank you so much, Judge. And that's all I have with this honorable court. May me and my client be excused.
You and your client may be excused along with Ms. Farias. Okay, thank you so much. Have a good day.
Ms. Farias, I'll be calling you in about a week to come put your signature in so we can review the documents.
Okay, that sounds good.
All right,
Thank
thank
you.
you. Y'all may be
Thank you,
excused.
Judge.
Thank you so much.
You have a
Bye-bye.
great day, Your Honor.
You too, sir.
Number 7.
Number 7.
No, who this lady is.
All right, number 7. Let me see here. CL 220058D, Gerardo Castillo et al. And occupants versus U.S. Bank et al. We have Mr. Ferguson, Mr. Chris Ferguson, right there.
Yes,
Good
Your Honor.
morning. Good morning.
Good morning.
And then a young lady there on the mics, 21 Ultra. Who are you, ma'am? Your name?
What case is she in?
You need to unmute.
Hi,
me.
Your Honor. I'm Raquel Merrill. I've been on my computer waiting to be let in. I'm number 5 on your docket.
Okay, yeah, we're not ready for your case, ma'am. That's
Oh.
why you're still in the waiting room.
Okay, we'll call you later, ma'am.
I wanted to make sure. Sorry, I get a little nervous. I just wanted to
Okay,
make
no,
sure.
no,
that
no problem. No problem. Thank you, ma'am. Okay, Mr. Chris Ferguson. Is there opposing counsel, Mr. Ferguson?
Your Honor, there's a opposing counsel that's filed an answer and a wrongful foreclosure suit. And I'm not sure was given notice of the hearing or the status conference this morning, Your Honor. I'm not sure why he's not here.
And who's that person?
Let me double check. I apologize, Your Honor.
Just in case they're in the waiting room.
Yeah. That, Your Honor, is Michael Hord with Hirsch and Westheimer. Hord,
Okay.
H-O-R-D.
H-O-R-D, Michael Hord, attorney. I don't see, there's Mike's, is that,
That's the Raquel Merrill. She's using Mike.
but Raquel Merrill is over here.
She's on 2.
Okay. So you don't think that's the one? Because there's 2 there.
That's the lady. This is the lady that we just put.
We just
back
put
in.
them back in there. And so Raquel Merrill is up there by herself. Okay. All right. And so, no, I don't see him in the waiting room. What were you going to ask today, Mr. Ferguson?
We're ready to go to trial, Your Honor. So we're looking for a trial date.
Okay. Submit an order for trial on the merits bench trial.
Yes, sir.
And with, of course, notice to opposing people and attorneys.
Okay.
And if you got their email or whatever, just put it in there, and they will get you a date. Yes, sir.
Okay, the bailiff just texted me, is there a something pending in federal court on this case?
There's a suit pending in federal court, but there's no injunction or anything preventing us from moving forward with the forcible detainer.
Okay, forcible detainer, possession, or whatnot. There's I see this gentleman here on the screen. Is that Mr. Castillo?
Señor Castillo, ¿habla inglés?
No.
Okay, and Mr. Castillo, so which case? On this one?
¿En qué caso está usted, señor Castillo?
I think it's this one, Gerardo Castillo and Alicia Castillo.
Could be, Your Honor.
Yeah.
That's the name of the
Yeah.
defendant.
Okay, name of the defendant. Okay. All right. Well, today's setting, I mean, for today, the court's going to set the matter for a bench trial. So we're going to have to get an order. Let's pick a date, and then we'll hear the evidence. So that's what we're going to do, okay? And you may want to explain that to
you
Mr.
want to choose from, Your Honor, or will you go ahead and assign the date?
Yeah, I'll accept. Yeah.
Señor Castillo, lo que hoy no va a ocurrir nada. Lo que va a pasar es que la corte le va a poner a una audiencia para un juicio sin jurado y va a ser en el futuro. El abogado va a archivar una orden donde la corte va a poner la fecha y entonces ya se les notifica. Todavía no sabemos si va a ser por Zoom o si va a ser en persona, pero esa orden ahí le va a indicar. Es importante que si usted tiene evidencia, tiene testigos, tiene fotos, que todo eso esté listo para ese día, ya sea por Zoom o en persona.
Ok, una pregunta.
Question.
Tenemos la audiencia, una orden que se hizo la demanda al día 11 de febrero a las 9 de la mañana en la Corte Federal, en el mismo caso.
I have a question. I have an order here that we have a hearing on February the 11th with a hearing that is set in federal court.
Okay, and I think that's a separate matter.
Sí, la corte sabe de eso y me parece que ese es algo separado, no tiene nada que ver con esto.
Right.
Ok, entonces yo obedezco las órdenes del juez. Que me diga.
Por favor, cuando usted reciba esa orden, como le digo, ahí le va a indicar si va a ser por Zoom o si va a ser en persona. Es importante que usted se presente.
Con todo gusto.
Ok, muy amable, gracias.
Okay, Mr. Ferguson, submit the order, please, and we'll set it for bench trial.
Okay, thank you, Your Honor.
Does he have Mr. Castillo's information?
Yes, I'm sure he does. You have Mr. Castillo's information, Mr. Ferguson?
I have his address. Does he have an email that I could use?
Señor Castillo, ¿tiene usted un correo electrónico?
Correo electrónico, con gusto, es Matrix.
A ver, ¿qué es?
Es Matrix con M-A-T-R-I-X. Digital. Digital. D-I-G-I-T-A-L. 11 @ yahoo.com.
Okay. Okay.
Okay, otra vez, Mr. Castillo.
Con gusto. Matrix con M, o sea, M-A-T-R-I-X.
Okay, Matrix.
Matrix.
Okay.
Dot. Matrix dot en lo que sigue de
I-T-I-T-A-L.
ok, es que se cortó la
Es que se está cortando, no.
ya.
Quiso traer una llamada al yo la rechacé. Vuelvo a repetir. Digital. D-I-G-I-T-A-L.
Digital.
Once.
Matrix dot digital.
No, es Matrix Digital, todo junto. 11.
Matrix. Okay. 11.
Arroba.
11.
11 arroba yahoo.com, por favor.
Arroba.
En yahoo.com.
Yahoo.com.
Matrix digital 11 at arroba yahoo.com.
Sí, señorita, con gusto.
Did you get it, Mr. Ferguson?
And how is he spelling matrix? Is it
Matrix.
okay?
Señor
Digital.
Castillo, deme su domicilio. ¿Dónde recibe usted la correspondencia?
407 Manhattan, 5, en Donna, Texas. 78537.
75.
No, 78537.
407 Manhattan.
407 Manhattan.
In Donna, Texas.
Okay. His mailing
Donna,
address
Texas.
is 407 Manhattan in Donna, Texas, 78537.
Okay, we'll mail it, and I have his email. I don't know if this is correct or not, but I have it at matrixdigital11@yahoo.com. Is that?
Yes.
Okay, but we'll do both. We'll email it, and then we'll mail it. We'll drop a copy in the U.S. Postal to the address.
All right. Thank you very much.
So, la
All right.
notificación, señor Castillo, le va a caer por correspondencia al domicilio que acaba de indicar y por correo electrónico.
Okay. All right. Thank you all so much.
Muy
Bye-bye.
All right, thank you. May I be excused, Your Honor?
You may be excused. Thank you, sir.
All right,
Bye-bye.
thank you. Have a good day.
Bye-bye.
Una
You
pregunta.
too. Bye-bye.
Aproximadamente, ¿cuánto tiempo mandará la carta?
No les sabré decir, señor.
Ok, muy
Porque
amable.
tiene que
pase buen día.
ser
Bendiciones.
archivado por el abogado y luego entonces ya la corte lo recibe y le pone la fecha y sale, ¿ok?
Okay. Thank you, sir.
Dios
Bye-bye.
lo bendiga.
Gracias.
Bendiciones.
Igualmente,
Gracias.
pase buen día.
Bye-bye. All right. Who's next here?
This Raquel. Ms. Raquel,
Okay. Which is that? Which,
number 5.
5.
Okay, she's on.
All right. Let's see here. Raquel Merle, right?
Yes, yes, Your Honor.
Okay. And I think you're here on CL 21-35-73D Raquel Merle versus
Yes.
Jorge Martinez and all other occupants.
Correct.
Jorge Martinez. Is there Jorge Martinez
No,
in the waiting room? No Jorge Martinez?
No.
Okay. This is an appeal from JP Court, right, ma'am?
Yes, Your Honor. This is an eviction. I just need a writ of possession.
Okay.
They've been in my home for over a year and have not paid a single penny in rent.
Okay. They're the ones that make the appeal?
Yes,
The appeal from JP Court?
yes, yes, Your Honor.
They found one.
Okay. I have a question. Do you know if they filed an appeal bond?
They did not. I called the court clerk and they
Okay.
did not file an appeal bond. And as a matter of fact, on their affidavit, they actually lied because on the affidavit they said that they pay $900 in mortgage,
Mhm.
which they don't. They haven't paid in over a year.
Okay. Okay. If they did not file the appeal bond, this case can get dismissed.
Perfect.
And then I'm not too sure if this court gives you the writ or it'll be the
I
JP
asked
court.
I asked the JP court and they said that Your Honor could do it.
Okay. Then you need to submit an order
Okay.
where we have the case dismissed and at the same time issuing you all writs that are required.
Okay, Your Honor.
There's
I will do that.
some kind of paragraph that goes in there that says any and all writs that are required are hereby ordered by the court or granted by the court.
Okay,
No bond.
Yeah, I just confirmed right now, no bond is on file. So
Okay.
it'll be it'll be an order to dismiss,
okay.
and along with the order for the writ, can it be the same order, right? Or can we have to do one separate ones?
Because once you dismiss it,
I
you
know.
have no jurisdiction.
But I think we need to do the writ first and then the dismissal.
And then you need to put the number of days you're gonna give them to get out.
Right. Two
5, Your
separate
Honor,
orders.
they've had a year. They've
Right.
had a
It'll
whole,
be
they've had a whole year,
okay.
not 1
So-
cent in 1 year.
Okay. You want to do two separate orders?
No, it's gotta be one.
One order dismissal, and then there also to issue all writs. Yeah, do me an order, ma'am.
Okay,
An order dismissing the
an order to dismissal?
an order to dismiss the appeal,
Okay,
and along to grant you any and all writs that are required for your eviction.
thank you,
Okay.
Your Honor, so much. Thank you so
All
much.
right, thanks so much. Your excuse. Have a
And
great day,
do I
ma'am.
have to do any motion or just an order?
No, just the order.
Just the order. Okay,
Just
I'll
the
do
order.
that right away. Thank you, Your
All
Honor.
right, thank you, ma'am. Bye-bye.
Bye-bye.
The last one is number 6.
Appeal not perfected. Dismiss. Okay, number what? Number 6. What do we have at number 6?
Grisela Salas
Uh-huh.
and Milton Morocho.
Okay, are they both there?
Mr. Morocho.
Okay.
Milton, put on your camera and your audio, sir, please.
Wow. Hmm. All right, guys, welcome back, Miss Salas. I'm trying to get in here. Milton Morocho, but
He's on, but he has no camera and no audio.
okay. What is this case about, Miss Salas?
An eviction.
Okay, who got evicted?
No, I didn't. But it was because I didn't pay the month of December.
Okay,
But- But everything got paid.
okay. You're the person that's doing the renting. You're making the payments.
Yes,
You're the tenant.
yes,
Okay, and the owner of the property is Milton Morocho.
yes.
Okay, I'm trying to get him in, but I cannot.
He's in. He doesn't have audio
Okay,
or video.
no audio
Okay, let's see. He's logging on.
or video. Let me see if he's logging on the phone or something. Now he needs to unmute. Okay, Mr. Morocho, you need to unmute and I need to see some video. Mr. Morocho, you need to unmute and I need some video.
Judge, for the record, I've already texted him on the Zoom chat. He is not responding yet.
Yeah,
There he goes.
He's on. He's on.
He's on, Rick. As you speak, he got on. All right, you need to unmute. There it is.
Okay.
Can you hear me, Mr. Morocho?
Yes, yes.
Okay, okay. And Miss Salas is on the other side. There she is, Grisel Salas. Okay, and what do we have here, Mr. Morocho?
I was actually I did not. I evict Mrs. Grisel Salas, but I already got the judge before make the case. So
Okay.
that now I don't know why I was invited for this.
She paid him.
Okay, Has she, okay, has she been paying you?
The county, Hidalgo County sent me for 4 months.
Okay. 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 In the JP court, you evicted her in the JP court? Is that what it is?
Yes. And
Okay.
Edinburgh.
In Edinburgh. Okay. And so now she's appealing, right? You're appealing, Ms. Salas?
I appealed
Okay. And so how much do you owe on the property or what? Or on the rent?
0. I'm actually caught up until March.
You paid up till March. Okay.
Yes.
No, the county pay until February, 4 months. That covers November, December, January, and February.
Okay. So now the next payment is March.
March.
That's what she says. Are we okay now?
No, she pay, I think, I don't know what she pay. She pay to the county,
Oh.
and then she told me, she wrote in my email that today they're gonna decide to
registry of the court?
Yes.
refer to me.
Oh, okay. So Ms. Salas, you're paying to the court, to the registry of the court?
Yes, I already paid a full month's
Right.
rent.
So
for
now we
the-
got to get the money and pay Mr. Morocho. That's what we got to do.
Yeah, and then I'm caught up until April.
Yes. Well, your next payment
no,
is March, I
April.
think.
Okay,
Yeah.
so until March, the court, the Hidalgo County pay 4 months.
Okay.
November, December, January, and February.
Okay.
If the payment, the Mrs. Salas pay to the Hidalgo County is granted
Okay.
to me, that will be 5 months. That will be November, December, January, February, and March. Not April. So 5 months. Does it make sense?
There's $1,050 in
Okay.
the registry of the court,
Okay.
and that was deposited on December 29th. How much is the rent?
Okay.
1,050.
1,050 is the rent? Okay.
Yes.
Mhm.
So that cover 4 months.
Yes, I don't make my payment until April.
Is she behind right now?
Are you behind right now, Ms. Salas?
No, I'm very much caught up.
Okay. Well, that's what I thought, because you were telling me earlier that you've paid up to February, right?
Yeah.
That your
And
next payment was going to be March. That's what it is, right?
Yes.
yeah, unless the county gives the 1,050 that I paid for, and then I would make my next payment till April.
Well, right now there's an amount of 1,050 in the county.
Yes, that's what I paid for.
That's
Yeah.
1,050.
So, yeah, that's correct.
And then the county pays. Then the county pays you, Mr. Morocho? No.
Yeah, the county has paid for 4 months.
They've been paying you.
No.
She went to apply for help with the county.
Oh. Okay.
Mr. Morocho needs to do an order to request the 1,050 in the registry of the court.
And he's going to continue paying.
Exactly, and then this case can be dismissed.
Oh, okay. Mr. Morocho, I need an order from you so I can give you the money that's in the county clerk's office.
Yeah.
Okay, so.
Yeah,
what do
just
I
give me
need?
an order, just an order
1,050.
for 1,050.
1,050.
1,050. 1,050. Yeah, give me an order, a simple order with the style of this case and the cost number. Where is it? Here it is, CL 21 4255D. That's this cost number, CL 21 4255D. Yeah, in this cost number, give me a simple order just saying that the clerk is to pay you the 1,050, and I'll sign it.
Order to release.
Order to release the 1,050.
Order to release.
Order to release funds to you, Mr. Morocho,
And then an order of dismissal.
in the amount of 1,050.
Okay.
Then an order.
Okay.
dismissing the case.
Then we need an order also to dismiss the case.
Okay.
Order of dismissal. Order of dismissal. Order of dismissal. Okay? Where
Okay.
you are requesting the court to dismiss the case, and I'll sign it also. Okay?
So
That'll do it. That should do it. Thank you all very much. You all may be
Thank you.
excused.
Thank you.
Have a great day. Bye-bye.
Thank
You
you.
too.